Hello, and welcome to Defense Diaries. I am your host, Bob Mata. Hopefully, I'm going to be joined by my beautiful and brilliant co-host, Allie. She's trying to wrap up a MSA for a case that she has up tomorrow morning before we leave for Boston. So we'll see. We'll see if she drops in. I hope she does. This is our initial coverage of the Aaron Spencer case. I had a lot of people reach out to me over the past few days that this is a case that needs to be on our radar. And oh, how right you were. As soon as I just read the fact pattern of this case, I was all in. This case is one of those kind of moral dilemma cases, I like to call it, as I'm going to kind of read you the fact pattern, the way that we're going to go about doing this live tonight. I'm going to go through a couple of articles from some local papers that give you the background of the case. And then what I'm going to do is I'm going to go through the Supreme Court of Arkansas's decision that pulled the gag order, got rid of the gag order. It was a big decision by the Arkansas Supreme Court. And it's really interesting. It's really interesting. This is a case that we are definitely going to be following. So I think without further ado, let me pull up. I want to pull up the first article that I found. And I know, oh no. Oh, I got to turn off my fan. My shit. It's like, oh my God, the air is getting fixed tomorrow. I'm so excited. I'm so excited. Be done with fans and mobile units. It's really exciting. All right. Enough of that. Enough whining from me. All right, let me pull this first article up. And this article is coming from the Arkansas Times. And it's going to give us a pretty good idea of some of the facts. In addition to that, the Supreme Court opinion also gives us a factual background of what's going on in this case. And tonight is not going to be all inclusive of all the facts out there. I've heard various things about some shady shit that the sheriff was doing and things like that. We're going to dig into all of it. It's just not going to be tonight. I'm going to give you guys a real strong baseline of what this case is about. I believe that you guys are going to be fascinated with this case. I believe that everybody that hears about this case is going to have an opinion one way or another. And I'm anxious to hear what you guys think and feel about this case. I know how I think and feel about it, and I'm going to save that until the end. I think if you follow us and you know anything about me and you know what kind of father I am, it's probably not going to be a real tough situation for you to guess what my position on this case is. So, all right, let me pull this up, blow it up so y'all can see it. So that is Aaron Spencer cuddling some turkeys. So this again is from the Arkansas Times. Let's give them proper credit here. And the article is entitled "More Details Out on Father's Killing of Man Accused of Molesting His 13-year-old Daughter." Okay. The article was written by Matt Campbell back on June 24th, 2025. Okay, let's see. What? Oh my God. This thing it has a paywall. Whack. Does this one have a paywall? All right, I'm going to switch. I'm going to share this one instead. It doesn't have a paywall. So I am not, or you know what? I always say that. And then when there's a case that I'm deep in, I end up paying a subscription fee to the local papers because I want to be able to research based on what the media is saying. I mean, my favorite thing is obviously court documents, but due to the gag, there's not a ton available court document wise right now. I think that things will start coming out the further that we get into this. But all right, so again, this is the Arkansas Times. Again, it's Matt Campbell. This one was written May 29th of 2025. State Supreme Court lifts the gag order on father who shot man that he found with his 13-year-old daughter. Okay, so the Arkansas Supreme Court on Thursday vacated a gag order in the case of Aaron Spencer. All right, so if we got Arkansas folks, it's your typical shit. Seems to be an indigenous name. I'm probably going to butcher it. So I'm going to go with Lonoke. Give it to me. I'm looking now. I'm looking now in the chat to see if you guys have an answer. A Lonoke or Lonoke County man charged with second-degree murder in the death of Michael Fosler in October of 2024. Fosler, 67 at the time of his death, which is so fucked up. Lone Oak, thank you, Mike and M. And Canoni's corrupt court. I appreciate you guys. Lone Oak, that's easy. So Fosler, 67 at the time of his death, had previously been arrested and charged with several sexual offenses against Spencer's teenage daughters. Several doesn't even come close. He was charged with 43 counts of varying charges, all related to his sexual abuse of Michael Spencer's daughter. Calling the Lonoke County Circuit Court's gag order in the case a gross abuse of discretion, the Supreme Court struck the order in its entirety. The facts of the case, which quickly drew attention inside and outside of Arkansas, are straightforward. Fosler was arrested in July and charged with 43 counts, including sexual assault of a minor, internet stalking of a child, and possession of child pornography, some or all of which related to a relationship between Fosler and Spencer's then 13-year-old daughter. I mean, try to wrap your mind around a 67-year-old fucking grooming creep that got his hands on this 13-year-old girl. And the more that you learn about Aaron Spencer, the more incredulous it seems, because this was not some shitty father. This is a hands-on war vet hero, loving father. And how this could have happened, and I'm going to assume that it was online, per usual, the fucking devil. I mean, there's nothing scarier than our kids being online. There just isn't. Online is way scarier than out in the real world, and it's pretty scary out there too. But online is terrifying. It's terrifying. So again, the facts of the case, which quickly drew attention inside and outside of Arkansas, are straightforward. Fosler was arrested in July and was charged with 43 counts, including sexual assault of a minor, internet stalking of a child, and possession of child pornography. Some or all of which are related to a relationship between Fosler and Spencer's then 13-year-old daughter. Circuit Judge Barbara Elmore released Fosler on bond. Therein lies the rub. Now, when bond is set, for a case like this in Illinois, with 43 counts of aggravated sexual abuse of a child or a minor, internet stalking of that child porn, to the tune of 43 counts, the bail would be set at a fucking $1 million at least. This guy's bond was set so low that he was able to post it. and get out pending trial. So while he's out on bond, this fucking guy, like this case just is unbelievable. This guy continues to be a predator to this girl specifically. I mean, this dude gets out on bail, which the minute he made a phone call, sent a text, hit her up in some kind of chat, DM'd her, whatever, it's a violation of his bond. He's going back in. They're going to revoke his bond and he goes back in. But that doesn't happen. Aaron's not privy to what's going on. His daughter has clearly been groomed by this guy to the extent where, for whatever reason, she has been Svengali'd. I don't know what it is. It's hard to know what would have led to the circumstances which would have her back in this guy's company. But she was. So late one night in October, Spencer told the police that he heard dogs barking and went to his daughter's room to check on her. She wasn't there. Spencer called 911 to report her missing. Then he went, yes, this was his original victim. This is the original victim. This is the person that he received 43 counts. I mean, including obviously child pornography, which I have no idea if there are pictures of her. I don't know. I don't know. But the grooming and the manipulation of this kid is unbelievable. And it's such a cautionary tale, especially since he was able to get his filthy, disgusting paws back on her. So at any rate, Spencer leaves out the house. And a short time later, he finds his daughter and Fosler in Fosler's truck. And Spencer proceeds to force his truck off the road, talking about Fosler's truck. This leads to an altercation between the men, after which Spencer calls 911 again to report that he had shot Fosler. Fosler died at the scene. The state then later charges Spencer with second-degree murder plus a firearm enhancement in November. Spencer's case, like Fosler's, was assigned to Judge Elmore. He got bond. He got bond. He was given bond. Now, we can debate all day on the amount that bond was set at, but whatever it was not enough. This predator should not have been out on the streets, presumed innocent. The bond should have been set so high that he shouldn't have been able to bond out. But he did. And that's what leads to the situation. So in December, citing media coverage throughout the state and beyond, as well as statements from Spencer's attorney calling him a heroic father, the state requested a gag order. They asked Elmore to prohibit Spencer, his attorneys, any state or local agencies connected with the case, any judicial employees, any public officials, and any subpoenaed witnesses from discussing any facts of the case in public. So they want to try the shit in the dark. Why? Why do they want to do that? I immediately start wondering why. Because, again, it's one thing to protect the child and her identity. You redact her name. That's simple. It's very easy to do. She's not the defendant. She's the victim. He is the defendant. These are supposed to be public, these trials, constitutionally. There has to be an extremely serious reason behind why they are sealing things or gagging a case. So Spencer, of course, objected to the gag order. He argued that it would violate both his due process rights to a fair public trial and his First Amendment rights to speak. He requested a hearing in open court on the state's motion. 30 minutes after Spencer filed his response, Judge Elmore granted the state's request for a gag order without holding a hearing. Quote, "It appears to the court," Elmore wrote, Elmore is the judge, "that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial." Elmore then went a step further and, without being asked by either side in the case, ordered the entire matter to be sealed. The state Supreme Court was having none of it. The justice said the order was on its face a plain, manifest, clear, and gross abuse of discretion and in excess of its authority, and declined to uphold any part of the order in light of the order's clear lack of an evidentiary basis as a whole. The court looked at three categories. All right, so I'm not going to even read through this because we're going to read the actual opinion. Now, I don't know if we'll read the whole thing. It's pretty lengthy, but I want to get through quite a bit of it. All right, so let me pull it up here. I'm going to share this tab instead. All right, so this is from the Supreme Court of Arkansas. This thing just came down end of May. Okay. All right, so the opinion was written by Courtney Ray Hudson. So Aaron Spencer has filed a petition for a writ of cert requesting that a gag order entered in his Lone Oak County Circuit Court criminal case be vacated. He argues that entry of the gag order was a plain, manifest, clear, and gross abuse of discretion, and that there is no other adequate remedy but for the writ. We agree, and we grant the petition for writ of cert and vacate the circuit court's gag order. You know what? Hold on. I'm going to pull this thing up so I'm facing y'all while I'm reading it. Oh, I can't. Never mind. Okay. All right, so here's the background. On November 27th of 2024, Spencer was charged. Let me blow that up for y'all so you can read it. Okay, that's good. Spencer was charged by felony information with second-degree murder along with a firearm enhancement under Arkansas Code annotated Section 16-19-120 for the shooting death of 67-year-old Michael Fosler. The state alleged that on October 8th, 2024, Spencer knowingly caused Fosler's death under circumstances manifesting extreme indifference to the value of human life, a Class A felony under Arkansas Code annotated Section 5-10-103. The circumstances of the shooting were as follows. In July of 2024, Fosler had been charged with numerous sexual offenses against Spencer's teenage daughter, and he was released on bond. Hold on, let me blow this thing up a little more even. And he was released on bond. On the night of the shooting, Spencer awoke to his dog barking and realized that his daughter was gone. Spencer found a hoodie on a stuffed animal placed in her bed. As a result, he left in his truck to search for her. Spencer located Fosler's truck with his daughter inside, and he forced Fosler's truck off the highway. After an altercation, Spencer called 911 to report that he had shot Fosler. Fosler died at the scene. On December 4th, the state filed a motion for a gag order alleging that Spencer's arrest had garnered media attention throughout the state and the nation. Attached to the motion was a press release from Spencer's attorneys, Aaron Casanelli and Michael Kaiser, criticizing the decision to charge Spencer criminally as, quote, targeting a heroic father. The state also pointed to a television interview in which the defense counsel allegedly stated that they felt confident that the community would side with Spencer because every one of them would have done the same thing for their child or their neighbor's child or a member of their family. Now, actually, let me pop over. I've actually got that. I want to pop that up real quick, and then we'll continue on with the reading of the opinion. All right, so let me share this screen. So this is the offending, at least in terms of the trial court, the offending interview that took place. All right. Okay. So here we go.
Tonight, we're learning previously unknown details of a murder case so sensational the judge and prosecutors worried about conducting a fair trial. But today, a majority of the Arkansas Supreme Court basically released those details themselves, saying Aaron Spencer and his lawyers have the right to speak publicly about how the man accused of sexually assaulting his teenage daughter ended up dead last year. Let's recap how we all got here. Lonoke County deputies arrested Spencer last October, with the sheriff's office saying then only that he killed 67-year-old Michael Fosler after a fight and after he had found him with his teenage daughter. Prosecutors charged Spencer with second-degree murder. Court documents reveal Fosler was facing numerous sexual charges involving Spencer's daughter and had posted bond. Spencer's family took to social media. They started calling him a hero. His lawyers saying he did the same thing that any father would have done.
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
But that lawyer, Aaron Casanelli, made that statement in defiance of the judge in the case. Lonoke County Circuit Judge Barbara Elmore had put a gag order on the case and sealed almost every document. Spencer and his lawyers appealed that. And today, a strong ruling from the state's high court. The gag order violated Spencer's First Amendment rights, with 3 justices saying they thought the case should have been removed from Judge Elmore's court. That's not going to happen, but the ruling listed new details that we didn't know before. Spencer had discovered his daughter had snuck out. He jumped into his truck and found Fosler with his daughter inside that truck. The opinion from Justice Courtney Ray Hudson said Spencer forced Fosler off the highway that night. That's when they fought. And moments later, Spencer called 911 to say he shot Fosler. Casanelli released a statement praising the ruling and applauding the clear guidelines that it lays out for future gag orders. Justice Hudson writing that gag orders should be a last resort and not a first impulse. Spencer pleaded not guilty last year. He has a pretrial hearing scheduled for August 8th.
Love that judge. Love that judge. Judge is the guy. Judge is the guy. All right. Let's go back to this. Okay, so again, on December, we're back to the Supreme Court opinion of Arkansas. So on December 4th, 2024, the state filed a motion for a gag order alleging that Spencer's arrest had garnered media coverage throughout the state and the nation. Attached to the motion was a press release from Spencer's attorney, Aaron Casanelli and Michael Kaiser, or attorneys, criticizing the decision to charge Spencer criminally as, quote, targeting a heroic father. The state also pointed to a television interview in which the defense counsel allegedly stated that they felt confident that the community would side with Spencer, which we just heard. And she's not wrong. Because, quote, every one of them would have done the same thing for their child or their neighbor's child or a member of their family, end quote. The state argued that a gag order was necessary to preserve the integrity of the jury pool and to ensure the right of a fair trial for both the state and the defendant. The state proposed 8 content-based limitations on the speech of any party, any attorney, any agency connected with the case, directly or indirectly, any judicial employee or officer of the court, any public official now holding office, including but not limited to law enforcement officials, their agents, deputies, or employees, and any person subpoenaed to testify in the trial of the case. On December 9th, Spencer filed a detailed response in opposition to the motion for a gag order. He argued that granting the motion for a gag order would violate his due process rights to a fair trial, a fair and public trial pursuant to the 6th Amendment and the 14th Amendment, as well as his First Amendment right to speak, pursuant to both the Arkansas and the United States Constitutions. Spencer requested that a hearing on the state's motion be held in open court. On December 10th, 2024, without holding a hearing. Sound familiar? Does that sound like anybody that we know? Any judges that we might know in Indiana? The circuit court entered the order at issue, noting that the, quote, apparent public interest in this case and the resulting extensive news coverage, end quote, the court granted the state's motion with some modifications. As grounds for the entry of the order, the court stated, quote, it appears to the court that the dissemination by any means of public communication out of any out-of-court statements relating to the case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. Now, y'all know how I fucking feel about when judges and prosecutors talk about the state's right to a fair trial. The state doesn't have a right to a fair fucking trial. We understand that, right? Are we clear on that? Those rights are to the defendant. Again, I know I belabored the shit out of this point. The Constitution was written for us, the citizens, not the government. The prosecution, the cops, they are the government. Our constitutional rights apply to us, and us can be a defendant, a citizen who's been charged with a crime, not the fucking government. And to have a judge say that shit makes me want to puke. Seriously, this woman need not be on the bench because she doesn't understand the concept of our Constitution. It's plain and simple. It's plain and simple. Okay, so rant over. So as grounds for the entry of the order, the court stated that it appears the court that the dissemination by any means of public communication of any out-of-court statements relating to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial. The court further noted that it was, quote, seeking a fair balance between constitutional guarantees of a free press, end quote. The order implemented the 8 prohibitions requested by the state. It is the order of the court that no party to this action, nor any attorney or agency connected with the case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy, or employee of any such persons, nor any person subpoenaed to testify at the trial of the case, neither shall the defendant nor his family shall do any of the following. 1, release or authorize the release for public dissemination of any purported extrajudicial statement of the defendant relating to this case. So there's a footnote there. The order included several notations handwritten and initialed by the judge, including the addition of Spencer's family. 2, the release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have been determined by the court. Make any statements for public dissemination as to the existence or possible existence of any document, exhibit, or any other evidence. 4, express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. 5, make any statement outside of court for public dissemination as to the weight, value, or effect of any testimony that has been given. Issue any statement for public dissemination as to the identity of any prospective witnesses or their probable testimony or the effect thereof. 7, make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation in this matter. 8, make any statement for public dissemination as to the content, the nature, the substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. Okay, so oddly enough, I just finished recording Garcia 67, wherein the state was moving to have Allison removed for the case because she made an extrajudicial statement about DNA that we believe showed that other people may have committed the crimes. And there was DNA found at 2 separate crime scenes, one which was not related to Anthony Garcia, had nothing to do with Anthony Garcia, and they found this one individual's DNA at both the Hunter house and the Joy Blanchard house. Allison made a statement and was absolutely run out of the state of Nebraska on a rail. Allison said far less than this attorney did in that press conference. And this is after 2.5 years of them trying our client in the press. So it's coming. It's in. Garcia's coming. It's coming. I finally recorded an episode. And I'm going to follow it up really quickly with the next one. And then it's trial. So that thing's going to be rapid. Okay, back to this. But this thing like hits a chord because this was one of those cases where, oddly enough, it's exactly what I was talking about in our episode. So this order does not include one, factual statements of the defendant's name, age, residence, occupation, or family status. Two, the circumstances of the arrest, namely the time and place of the arrest, the identity of the arresting and investigating officers and agencies, and the length of the investigations. Three, the nature, substance, and text of the charges, including a brief description of the offenses charged. Four, quotations from or any reference without comment to public records of the court in this case, or to other public records or communications hereforto disseminated to the public. Five, the scheduling and result of any stage of the judicial proceeding held in open court or in open public session. Six, any request for assistance in obtaining evidence. Seven, discussion by any witness or prospective witnesses of any matter in connection with the state with any of the attorneys representing the defendant of the state. All parties and the defendant are under a gag order. So the order goes on to require that a copy of the order be attached to any subpoena served on any witness in this matter, and two, a redaction of any information violating the gag order from any paperwork related to the case that might be disseminated to the public. The order further states that it will be, quote, in force until such case has been disposed of or until this court orders otherwise. This order will help ensure that all parties get a fair trial. Oh my fucking God. Finally, the order provides that, quote, the entire case is now sealed. Thus, the circuit court adopted the requested prohibitions contained in the state's motion for a gag order with the qualifications listed in provisions 1 through 7 and the sua sponte sealing of the entire case. Footnote 2. We note that this order is nearly identical to the orders we vacated without written opinion in Arkansas Democrat Gazette, Inc. versus State of Arkansas, petition for writ of cert granted. Although the present order does not expressly apply to media outlets, the 8 prohibitions on speech and the 7 provisions for information not prohibited by the order use the same language as in the Arkansas Democrat gag order, styled orders regarding publicity. Arkansas courts shall no longer use this apparent form order. What they're saying is the good old judge here went online, found a fucking gag order, and copy and pasted it. Wow. On February 2nd, 2025, Spencer filed in this court a petition for writ of certiorari and for other relief. The state filed a response on February 12th, and Spencer later filed a motion to stay proceedings in the circuit court, take the petition as a case, and set a briefing schedule pursuant to Arkansas Supreme Court Rule 6-1F. Okay. Spencer also requested oral argument. Like, this is a case where everybody's going to have feelings about it. And that includes people with robes. That includes people in uniform. That includes citizens sitting behind their computer. This is the kind of case where, as his attorney aptly stated, I would have done the exact same fucking thing. I'm just telling you. Like, I'm going to skip way ahead. If I were on that jury, there is not a shot in hell I'm convicting him. And it's not even a jury nullification. I'm either going with defense of others or self-defense. I mean, from one thing that I saw, apparently Spencer made a statement that when this dude got out of his car, he saw that he had, or he thought that he had something in his hand. He didn't know what the fuck it was. They get into this scrum. He goes back to his truck, gets his fucking gun. This guy goes back into his truck. In the meantime, he's screaming for his daughter to get out of the truck. I mean, this manipulative fucking predator had gotten his filthy claws so deep into this poor kid, I have zero doubt that he saved her life. Zero doubt. I'm just telling you, I would have done the exact same thing. I'm saying it right here on a live that'll be out there for the entire world to see in perpetuity. I absolutely would have done the same thing. There's no question about it. So Spencer also argued or requested oral argument. We granted Spencer's motion to stay proceedings in the circuit court, took the petition for writ of cert as a case, set a briefing. I already read this, and granted Spencer's request for oral argument. The petition is now ripe for decision. Okay. All right. So I'm going to skip this part. This is, if I had more time, if I wasn't traveling tomorrow, I'd read this because I like the educational value of it in terms of teaching you guys what a writ of certiorari is. And, you know, if you're applying, if you filed a writ for cert, you're asking a Supreme Court, whether it be the US, whether it be a state, you're saying, hey, this is an issue that we need you to address. The appellate courts are fucking it up. We're going straight to the Supreme Court, or they've already fucked it up, and we need you to fix what they did. And that's it. And that's it. So, so we'll skip that. So this is the analysis. Okay, Spencer argues that the gag order violates the First Amendment because it is an unjustified prior restriction on certain content-based categories of speech. He further argues that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. The state responds that the circuit court's order was within constitutional limits, protects the integrity of the case, and ensures a fair trial for both Spencer and the state. For the reasons that follow, we hold the circuit court's action in entering the challenge gag order was on its face, a plain and manifest, clear and gross abuse of discretion in excess of its authority. Further, there is no other adequate remedy except for a writ of cert. So standing as an initial matter, and we've explained to you guys what standing is. I mean, you have to have standing in order to bring a case at all, not just at the Supreme Court or the appellate court level where you have to have standing. In any case, you have to have standing, which means that you have the right to bring the case, that you're an aggrieved party. So standing is an initial matter. We must address the state's argument in its response brief that Spencer lacks standing to challenge the order based on the constitutional rights of others. Indeed, as a general matter, constitutional rights are personal rights and may not be raised by a third party. However, the issues raised in this petition for an extraordinary writ require us to consider restrictions not directed towards Spencer personally. We decline to uphold any part of the order in light of the order's clear lack of an evidentiary basis as a whole. Here, the circuit court's order is extremely broad as to the persons restrained from speaking. It restrains the parties, their attorneys, any public official now holding office, along with their staff, witnesses, court staff, and the defendant's family. The order is also extremely restrictive as to what information is being shielded from the public. It restricts filings and perhaps courtroom proceedings from public view. The order implicates Spencer's right to a public trial as well as the public's right to know how its officials are conducting these criminal proceedings. The state points out that Spencer raises arguments regarding the gag order's application to public officials and to his family, the restriction on the public and the press access to the court file, and the due process rights of non-parties as to the entry of the order without notice. However, Spencer clearly has standing to bring this petition requesting that the court vacate the gag order in his criminal case, and we will address Spencer's arguments to the extent necessary to resolve the issues raised in the petition. Freedom of speech. The First Amendment to the United States Constitution provides, in part, Congress shall make no law abridging the freedom of speech. The First Amendment is made applicable to the states by the 14th Amendment. Similarly, Article 2 Section 6 of the Arkansas Constitution provides the free communication of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their sentiments on all subjects. Spencer relies on both the U.S. Constitution and the Arkansas Constitution in arguing that the gag order in this case violates his and others' free speech rights. However, free speech rights are not absolute and in rare cases must yield to the Sixth Amendment's guarantee of a fair trial by an impartial jury. See Nebraska Press Association v. Stewart, discussing the Sixth Amendment guarantee of a fair trial by an impartial jury as a basic requirement of due process. A gag order is defined as a judge's order directing parties, attorneys, witnesses, or journalists to refrain from publicly discussing the facts of the case. Black's Law Dictionary. So thus, a gag order is by definition a prior restraint on speech. Prior restraints on speech and publications are the most serious and least tolerable infringement on First Amendment rights. That comes from Nebraska Press Association. Okay. As such, a prior restraint on speech bears a heavy presumption against its constitutional validity. And that's cited from the Helena Daily World versus Sims, or Helena. I think it's Helena. In fact, the Supreme Court has recognized that criticism of the state lie at the very center of the First Amendment. This could include speech critical of judges, prosecutors, public defenders, and law enforcement. So, quote, it would be difficult to single out any aspect of the government of higher concern and importance to the people than the manner in which criminal trials are conducted. Hard agree. The Supreme Court of the United States has only directly addressed the constitutionality of gag orders as they apply to the press, not as to attorneys, parties, witnesses, or the public. Nor has the Supreme Court articulated a legal standard for when, if at all, such prior restraints would be permissible. In Nebraska Press, the court considered gag orders on the press and strongly disapproved of such prior restraints except in extraordinary circumstances. The court noted that pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial. The court stated that it was required to determine whether the gravity of the evil discounted by its improbability justifies such invasion of free speech as is necessary to avoid the danger. To do so, the court examined the evidence before the trial judge when the order was entered to determine the nature and extent of pretrial news coverage, whether other measures would be likely to mitigate the effects of unrestrained pretrial publicity, how effectively a restraining order would operate to prevent the threatened danger, and whether the precise terms of the restraining order were too broad or too vague. In Gentile versus State Bar of Nevada, the court considered the circumstances under which attorneys may be punished after speaking. The court upheld a prohibition on speech that presents, quote, substantial likelihood of materially prejudicing an adjudicatory proceeding, as provided for in Nevada's professional conduct rules. Gentile at 501 U.S. 1033. Importantly, the Supreme Court held that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press. Nebraska Press and Gentile provide guidance, but do not answer the question on when gag orders may be placed on attorneys, parties, witnesses, or the public in pending cases. Here, the gag order was intended to address, quote, the need to protect the integrity of the jury pool to ensure that all parties get a fair trial in light of pretrial publicity. When considering pretrial publicity, a trial court has the difficult job of balancing constitutional interests while upholding its affirmative duty to protect the integrity of the criminal justice process. The Supreme Court made this clear in Shepard v. Maxwell, when it granted habeas relief to a petitioner who had been deprived of fair trial in his state murder conviction because of the trial judge's failure to protect him from, quote, massive, pervasive, and prejudicial publicity, and from the carnival atmosphere at the trial itself. The Shepard court noted that, quote, the trial court might well have prescribed extrajudicial statements by any lawyer, party, witness, or court official which divulged prejudicial matters. We recognize that Shepard was an extreme case in which there was no doubt that the deluge of publicity reached at some of the that the deluge of publicity reached at least some of the jury. So the court ultimately concluded that Shepard had not received a fair trial consistent with the due process clause of the 14th Amendment and reversed his conviction. While intense publicity can prejudice a trial, we note that, quote, an impartial jury need not be wholly unaware of information, including potentially prejudicial information outside of the record. And that's cited from In re Murphy Brown. We now turn to the arguments which regarding which standard should apply to prior restraint on speech in the context of this case. To justify a prior restraint on speech, there must be a factual showing of necessity. In other words, the court must determine whether the circuit court's order is justified by a sufficient risk of material prejudice to an ongoing judicial proceeding. This court has explained, quote, the question becomes whether the justifications for the restraining order are of sufficient weight to eclipse the substantial weight of the interests protected by the First Amendment, which dictate the heavy presumption against the constitutional validity of prior restraint. All right. So what then is the necessary showing? Spencer argues that a gag order is permissible only under the highest level of scrutiny. That is, if there is a serious and imminent threat to the administration of criminal justice. In contrast, the state relies on Gentili and argues in favor of a heightened standard that is less rigorous than strict scrutiny. In the absence of Supreme Court precedent, the federal circuits and the states have taken different approaches to gag orders. Some courts have adopted the clear and present danger or serious and imminent threat standard, see U.S. v. Ford, requiring a serious and imminent threat to restrain the speech of a criminal defendant. Levine v. U.S. District Court, requiring a clear and present danger of a serious and imminent threat for a prior restraint on attorney speech. Chicago Council of Lawyers versus Bauer, applying serious and imminent threat standard. And then U.S. v. Trump, 2023 case. We hold that some aspects of the defendant's speech pose a significant and imminent risk to the fair and orderly adjudication of this criminal proceeding, which justified protective action by the district court. Briner versus Takeo, where extrajudicial statements of attorneys may be subject to prior restraint by a trial court upon a demonstration that the activity restrained poses a serious and imminent threat to the defendant's right to a fair trial and to the fair administration of justice. Now, this is interesting. So what the Arkansas Supreme Court is having to do is they're having to dip into several other federal courts, various federal circuits, and they're having to do that because the Supreme Court, as to this particular issue, because they've only addressed it as to the press and not to individuals and or attorneys and judges and politicians, they've been silent on it. So that's why they don't have that precedent from the Supreme Court to say, all right, here's a bright line rule. This is what the law of the land is because the U.S. Supreme Court said so. So that's why they're citing all these different cases. And they're trying to determine, based on what all these other circuits are doing, these federal courts, in terms of what standard to apply in this particular situation. So they go on and on, citing various cases. So they then try to address the state side of it. So still other courts have adopted a reasonable likelihood of prejudice standard. Okay. And they've got James v. Hines, before entering a gag order restraining trial participants The court must first determine whether there is a reasonable likelihood that pretrial publicity will prejudice the defendant's right to a fair trial. So when determining which standard to apply, we must so now they're going to their rationale. So they're going to apply the things that they read in these different opinions, and they're going to apply them to what they're thinking in terms of coming to an opinion on this. So when determining which state standard to apply, we must initially recognize whose speech is being restricted. We can identify three categories of persons potentially subject to gag orders. One, attorneys of record. Two, non-attorney trial participants, such as criminal defendants, witnesses, and court staff. And three, the public at large, i.e. those who are not participating in the trial. And then they have a footnote there. So we do not address gag orders on the press in this opinion because the order before us does not impose restriction on the press, nor does any member of the press challenge it. We know that this court has previously addressed gag orders placing prohibitions on the press. And again, Arkansas Democrat Gazette v. Zimmerman. Okay, so because the gag order entered here included members of all three categories, we review each to establish the appropriate standards. First, we address attorney speech. The Supreme Court has recognized that speech by an attorney is subject to a greater regulation than speech by others. See Gentili. The court recognized that states have historically regulated admission to the bar and exercised authority to discipline attorneys, and attorneys have access to non-public information and are viewed as authoritative, both of which pose a greater potential risk to the fairness of a trial. And attorneys are officers of the court. For the same reasons, we find it appropriate to allow greater regulation of attorney speech in the context of a criminal trial than would be permissible for the speech of a non-attorney trial participants or members of the public. Thus, we hold that attorneys in Arkansas may be restrained from extrajudicial speech that poses a substantial likelihood of material prejudice to an ongoing criminal proceeding. This is consistent with attorneys' existing obligations under Rule 3.6 of the Arkansas Rules of Professional Conduct regarding trial publicity. Next, we consider the free speech rights of non-attorney trial participants. These persons are not subject to the same rules and restrictions as attorneys, but as participants in the trial, their speech has the potential to have greater impact than the speech of non-trial participants. And then they cite Shepard. Neither prosecutors, counsel for the defense, the accused, the witnesses, court, staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Thus, we conclude that free speech protection for non-attorney trial participants are greater than those of attorneys of record, but less than those of public at large. That's interesting. So thus we conclude that the free speech protections for non-attorney participants are greater. Okay, so what they're saying, if you're confused by that, it's kind of written strangely. So they have greater protections, meaning that they've got to show more to shut down non-attorney trial participants than they do lawyers. Okay, so therefore we hold that the speech of non-attorney trial participants may be restrained only to the extent that it poses a serious and imminent threat of material prejudice to an ongoing trial proceeding. Finally, we address prior restraint on the public, whose speech is afforded the most protection in the context of gag orders. Restraining the speech of the public raises obvious issues regarding the lack of due process. We cannot fathom why the circuit court believed it could prohibit the speech of, quote, any public official now holding office. In fact, it is difficult to foresee any circumstance in which a prior restraint of the speech of a member of the public, which would include a public official, could be constitutional. Having established the legal standards to be applied, we then turn to the additional findings a circuit court must make in every case to justify the entry of a gag order restricting the speech of any individual. First, the circuit court must determine whether alternative measures would protect the party's right to a fair trial. Here, Spencer suggests that extensive voir dire of prospective jurors using an expanded jury pool, giving cautionary instructions, changing venue, or postponing the trial are alternatives that should be considered before restraining speech. But the circuit court heard no evidence and made no findings in this regard. In addition, the circuit court must find that a gag order would be likely to accomplish the goal of preventing prejudice to the proceedings. Again, there was no such finding in this case. Finally, a gag order must be narrowly tailored to prohibit only what is necessary to protect the integrity of the ongoing judicial proceedings. So, in other words, the restrictions imposed must not be overly broad. Here, many of the prohibitions on speech listed in the gag order were overly broad. For example, prohibiting the public expression of an opinion as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant by any public official is clearly overbroad. In sum, before entering a gag order, a circuit court must specifically find, based on evidence in the record, one, that perspective of limited speech would pose a sufficient threat of material prejudice to an ongoing criminal proceeding, depending on whether the limitations apply to the attorneys of record, non-attorney trial participants, or members of the public. After consideration of alternative, less restrictive means or measures, none would sufficiently protect the party's right to a fair trial. 3, the prohibitions would be likely to prevent material prejudice to the proceedings. And 4, the prohibitions are narrowly tailored to prohibit only what is necessary to prevent material prejudice to the ongoing proceedings. So, as to the due process aspect, Spencer also argues that the order is impermissibly vague and that it is impossible to know what is covered by some of its provisions. He states that it is unclear, for example, whether statements on social media are restricted or must be removed, whether previously public filings now removed from public access may be shared, what, quote, for public dissemination means, and precisely who this gag order restrains. Spencer also argues that it is unclear what exactly prohibition number 8 seeks to restrict. According to that provision, the named individuals cannot, quote, make any statement for public dissemination as to the content, nature, substance, or effect of any testimony which may be given in any proceeding related to this matter with any attorney of record or agent thereof. The state, of course, maintains the gag order is not unconstitutionally vague. Surprise, surprise. See, like, this is unusual. Like, the prosecution in this case, because of how this case is factually, because they have a clear understanding that the public sentiment, by and large in this case, is going to side with Aaron Spencer and what he did. That's facts. That's facts. Now, will there be some people that are saying, hey, this is like, I mean, we don't know all the facts in terms of exactly how it went down. That's going to be a trial. We will not know that until trial or until there are pretrial motions that are pled in which statement of facts come out. Because when I went and looked at the information, which means it went to a grand jury, it was very, very vague. Like, they did not, it wasn't like a PCA, right? Which probable cause affidavit you're getting, that is the other way to indict somebody or to charge somebody officially. And the other way is by grand jury, which is what they call an information. So, or an indictment. So this indictment just was super, super vague. So I like, if there is some kind of factual affidavit out there, I hope that it's made public, because I'd love to know more facts. I'd love to know what drove the state to file these charges. Because if you've got this guy being who he is, who is out on bond, who is alleged to be a horrific predator, and he's now got his hands on the very same girl that he is alleged to have sexually abused, and he's out on bond, and his father goes to save his child from that predator, and a fight breaks out, I mean, like, you have to think, if this guy is psychotic enough to be out on bond or so unhinged or has such a compulsion to do what he's doing that he just says, fuck it, I'm going out and I'm getting this girl again. That this guy doesn't care about anything. That's what I'm thinking if I'm Aaron Spencer. And when the shit goes down, if I think that this guy is potentially going to harm my child and or worse, and we are in a physical altercation and he's taken something out of his vehicle and I'm not sure what it is, I mean, it is going to be exceptionally difficult to convict him. I just find it very, very strange based on the factual circumstance that they charged him. Because it's not just that situation where you find out that somebody is abusing your child and you hunt them down and it's straight vengeance. This is different. This is different. This isn't straight vengeance. This is a situation wherein this guy was charged, he was able to bond out, and then he continued coming after his daughter to the extent where he finds his daughter, his 13-year-old daughter, in this guy's truck. He has to run him off the road. That's what I'm saying, Miss Wild. I don't know that it is vigilante justice. That's what I'm saying. That's why I'm trying to make clear to you, this isn't that type of situation where, you know, I'm going like, who's the guy who shot the dude when he was in cuffs? I forget what his name is all the time, you know, but he was like lurking and hanging up by the payphone, the bank of payphones, turns around and shoots him. You know, and he's always been seen as a kind of a heroic vigilante. This isn't that. This isn't vigilante justice. Again, I'm going to restate it. I'm going to restate it. This guy got out on bond for allegedly having physically and sexually assaulted this very child and went and got, in violation of the court order and the conditions of his bond, went and got her again by whatever means he did it. I don't even think it's nullification. I don't think it's jury nullification. I think that they're going to find that it was a justified homicide, either for defense of others. Now, I don't know what the defense is going to be, but it's either going to be one or both defense of others or self-defense. If he had a reasonable fear that this guy was going to kill him or cause serious bodily injury, he was justified in his actions. If he had a reasonable fear that this guy was going to harm, cause serious physical harm, or kill his daughter, he had every right to step in and save her. That's how the law works. This is going to be a self-defense case, which, as you all know, are my favorite cases. I love them. This isn't a whodunit. This is a, was he justified in his actions? They're not going to, this isn't going to be like jury nullification. Jury nullification is that other situation, like where the guy's standing at a bank of phones, they're bringing him out in cuffs, and he turns around and shoots the guy dead, and then they arrest him immediately. The guy is clearly not a threat to him. And, you know, that's a jury nullification case. This is going to be a case wherein facts are going to be put out that this guy was reasonable in his actions. Therefore, it is a justifiable homicide. Remember, every homicide doesn't mean that you're a murderer. There is justifiable homicide in this country. And that defense of others is going to be a thing. I'm just telling you. And if you think that 12 people on that, It's either going to be a hung jury in perpetuity or he is getting acquitted. That's my guess. Gary Plache, yeah, that's it. Thank you, Miss Wild. That's exactly what I was talking about. That dude, like, had he been acquitted, that would have been jury nullification. Completely different situation than this. Completely different situation. All right, let's keep rolling. Okay, so the void for vagueness doctrine addresses at least two connected but discrete due process concerns. Regulated parties should know what is required of them so they may act accordingly, and precision and guidance are necessary so that those enforcing the law do not act in an arbitrary or discriminatory way. Citing FCC versus Fox Television. Stated differently, the prohibition against vague regulations of speech is based in part on the need to eliminate impermissible risk of discriminatory enforcement, citing Gentili. So vague prohibitions also create a chilling effect on speech because one does not know precisely what speech is prohibited. Here, we agree that the gag order is unconstitutionally vague and must be vacated. For example, who is included as part of Spencer's family? Does the order purport to restrain the speech of his second cousin or only that of his parents, spouse, and children? Due process requires more specificity. In his petition for writ of cert, Spencer does not develop his due process argument regarding overbreadth, but in briefing, he clarifies his assertion that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. It is unnecessary to address overbreadth as a due process violation in this case. Our decision is governed by the free speech and void for vagueness analysis above. Sealing the case. Finally, we address the circuit court's decision to seal the case. Spencer contends that the community has a right to know what its government does in public court proceedings. He cites Arkansas Code annotated section 1610-105, which provides, quote, the sittings of every court shall be public, and every person may freely attend the sittings of every court. It's got footnote 4. This court has recognized that an accused may assert his constitutional right to a public trial by arguing that exclusion of the news media and the public violates that right. Here, after the court's order was entered, the case filings were removed from the public view. The inherent authority, who's that? Oh, Mandela. What? I'm on a live. All right, go through. All right, hold on. I got to pause it. All right, hurry up. Go. Okay. Scarlett and her cousin were going to take a shower in their bathing suits. Okay. Back to the business at hand. Okay. The inherent authority to seal parts of the court files is tempered by the requirements that a request to seal part of the file must be particularized. And there must be some good cause for sealing part of the file, such as trade secret, and that it should be in effect for only so long as is necessary to protect the specified interest. Okay, so not only are the written records inaccessible to the public. Am I on the right page? Oh, yeah. Okay, not only are the written records inaccessible to the public, but also the briefs and the statements from counsel at oral argument indicate the Lonoke, did I say it right? I feel like I did. Lonoke County Circuit Court's courtroom was at least partially closed to the public during Spencer's arraignment. Although it appears the circuit court intends to close further proceedings to the public, we caution the court from doing so without an evidentiary basis and adherence to the required constitutional analysis as set out in Waller v. Georgia. As we stated in Schnarr v. State, the right to a public trial is one of the most important safeguards in the prosecution of persons accused of a crime. Hear, hear. So conclusion, the circuit court's gag order is far too broad and too restrictive of speech protected by the First Amendment and Article 2, Section 6 of the Arkansas Constitution. It is also impermissibly vague. Further, the order was entered without the requisite findings discussed above and wholly without a factual basis. Therefore, we hold that the circuit court's order constitutes a plain, manifest, clear, and gross abuse of discretion for which There is no other adequate remedy. Accordingly, we issue a writ of certiorari and vacate the order. By this ruling, we do not foreclose the possibility that after an evidentiary hearing, the circuit court may issue a subsequent gag order narrowly tailored to specific factual findings supported by the record. However, we emphasize that the gag order should be a last resort, not a first impulse. Thank you. Thank you, justices there. So there's a concurring opinion. We're going to skip that. All right, so there you go. So the thing is ungagged at this point. And I'm hoping that we are able to get more information on this case. Now, I'm going to be digging in. Tracy and Mandy will be digging in. We will be trying to find out what we can find out, see what we can see. And we're like, it's sad to me that there's only 357 people. What? Because it's not Karen Reed? Come on, man. There's other shit going on. Like there's other cases that are like important to follow. But hopefully people will get wise to this one. I realize it's the ride or dies in here. You guys are the real ones in here. You guys are the real ones. And if you're new, give us a sub. We'd love that. All right. So only got one super tonight. So eBay Warhol. Looks like we are going back to the upside down world, only now we're in Arkansas. It's got that vibe, doesn't it? It really does. And obviously Tracy's referring to the good old state of Indiana and how they tried that case in the cave-like darkness of Carroll County. So yeah, I'm this is a case that I'm thrilled. Like, here is what I'm hoping comes. Like, when you have the Supreme Court of your state body slamming some piece of shit order you put out, I hope it's going to give her, and calling her out for cutting and pasting that particular gag order. I hope that's going to put a real wrench in her gears. I hope that's going to have a huge chilling effect on her and make her really hesitant to gag this case. Because again, I can see why the state doesn't want the people talking about this case. I can see why, because public sentiment is going to be behind the defendant in this case. It just is. So, it makes sense. It makes sense to me. So, I think it's an important case. I think it poses an important question. How far would you go for your kid? What would you do to protect your child? When you get down to brass tacks, that's what this case is about. And ultimately it's going to be decided, were his actions reasonable and justified under the circumstances. That's how this thing, I cannot see any way that this, there is no way that this dude's ever taken a plea. Not unless they drop second degree murder and make some kind of like battery offer. He's going to trial on it. Like, this is one of those cases they're going to go to trial. Like, typically, if you've got a strong self-defense case or defense of others, like, those things go to trial because you have to fight them. You have to fight them. And it sounds like there's more stuff out there. Oh, Big Dog, I felt bad for you. One super chat from Arizona. We have the heat, so sympathize. Just send rain to us send rain to us occasionally. Thanks, Big Dog. Yeah, we got a nice rainstorm today. And my pain is over tomorrow. The 3 weeks of hell being a house without air conditioning that gets really hot is all over. I did read the demographics, Mandy. It was interesting. It was interesting. I didn't read them on the live, though. I didn't read them on the live. Let's see. So Mandy had sent some demos, and they're interesting. So Cabot is the largest city in Lonoke, Am I pronouncing that right? Or did I forget? Yeah, Lonoke, I think. County, Arkansas, Little Rock, the state capital, is only 22 miles southwest of Cabot. Population of Cabot is 82.56 white. As of 2020, the United States Census said that there were 26,569 people, 9,780 households, and 6,967 families residing in the city. Median income for the household in the city was just shy of 50 large at $49,389. And the median income for the family was $53,933. The Cabot Public School District has been designated as a Purple Star school district for its support of the military families, particularly those serving as a at the Little Rock Air Force. And again, this guy's a vet, so that's why that's pertinent. Also, there are 43 churches in Cabot. The person-to-church ratio, with a person-to-church ratio of 1,618 people per church. So the Cabot Public Schools, Walmart, USPS, and Bancroft Cap Company are top employers in Cabot. Bancroft is a manufacturer of hats and caps, notably known for supplying berets to the U.S. military. All right, so there you go. There's some fun facts. All right, so I hope I got you guys onto this case. It's a crazy, like, and the more that we hear about it, the more crazy it's going to get. But, like, I mean, if the concept of this guy ended up shooting and killing the guy who had been charged to the tune of 43 counts of varying sexual predator crimes against his very daughter, who got out on bond and went and arranged for him to get his filthy hands again on this girl. If that's not enough to draw you in, I don't know what is. Because factually, it's way more interesting than Karen Reed. Just is. It just is. So hopefully y'all are going to... Oh, all right. See you guys Saturday at the Boston Festival. Amy, did you use our code? That's what I'm trying to ask you. I feel like you didn't, because every time I ask somebody, people aren't like, oh yeah, use your code. I mean, it saved you 20%. If you are coming to the True Crime Podcast Festival that is this weekend in Boston, Allie and I are flying out tomorrow, make sure you use Defense20 code to get 20% off your tickets. Do you hate money? Like, you have to hate money to not use the code. Who wouldn't want 20% off their tickets? So use it. So thank you. I look forward to seeing you, Amy. Truly, truly. Alicia, thank you, Amy, and thank you, Alicia. Thanks for covering this case. There's some deeper stuff to it, and the corruption continues to worry. Yeah, and it's the deeper stuff that I want to start digging into. And if we got any people then that have been digging into this case, and I only want factual shit. I don't like the speculation stuff. Like, that's not my deal. I like stuff that's factually accurate. Like, I don't want to be guessing. I don't want to be speculating. I want things that are factual and substantiated. Like, that's what I care about. Oh, good. Good, Cammie. So you make sure you give me all the deets that I need. All right. So that'll do it. Oh, for Aaron. Thank you so much, Sky. Oh, you guys came in a little late with the love. I appreciate it so much. All right. So again, Friday, I'm going to be doing a man on the street interview from the True Crime Podcast Festival. Tons of awesome creators there. I think you guys it'll be fun. It'll be like a lighthearted, fun live. I think you guys will dig it. It'll be a good way to kill some time on Friday. I promise. My man on the street interviews are fun. And, I play around a lot. It's goofy. So, they're a good time, and you're going to see a lot of creators that you may know and love. So I look forward to that. Can I go and find... No, Aunt Deb can come find me, Mandy. Get the shit right. Why would I go find him? He can come find me. Like, he knows where I'm at. So tell him to come find me. Tell him he can come on. Shit, I'll get him a table. Set him up. Hook him up. Get his True Crime Podcast Festival on. Do the work. Do the work. Yeah, I'll try not to. Try not to. I think I'll be safe in there. I think I'll be safe in there. So again, Friday, that's that. Tuesday, we are having Bob Ruff on to talk about his new case that he is digging into, which I'm not going to tell you anything about. You're going to have to come and check it out in his 17th season of Truth and Justice. Followed by, I have just been invited to the advisory board of a justice and exoneration project out of Purdue, which I'm super excited about. I'm going to have Nikki Jackson, who is the founder of that, and it's got some pretty neat people on the advisory board. So I'm really excited about it. I'm honored to have been asked, and you guys are gonna love Nikki. She's like she's a lot like Allie, and she's a pit bull, but she fights for justice, and it's based out of Purdue University. So I'm excited to have her on. I also got word tonight that I was at some point next week, David Middleman, maybe Kristen Middleman, hopefully the both of them, of Othram Labs, the founders of Othram Labs, are coming on. I'm super excited about it. If you don't know who Othram is, Google it. You'll find out real quickly. It's going to be an amazing live. I'm super excited to have them on, and I think it'll be amazing. So that'll be sometime next week, and I'm looking forward to it. Othram does really amazing work. They're the DNA lab down in outside of Houston that is doing the most incredible work. Yeah, Othram is doing a podcast now. That's why I reached out to him, and I'm like, I mean, I know David, so I went and toured the lab. I'm like, I want to have you on. You guys come on, talk about the pod, talk about the lab, tell us all the amazing shit you're doing. So that will be awesome. That will be awesome. If you don't know anything about Othram, if you don't know anything about the advancements that they've made in DNA technology, next week will be the time to figure it all out with what I consider to be the unrivaled lab in the country, in the world, frankly, in terms of what they are doing. They are, I mean, like anytime you're hearing about a lab that's able to identify John and Jay Does that have been unidentified for 100 years, it's Othram. They are doing amazing work. And the other thing that I'm working on is Amanda Knox. I think I'm awfully close to getting her on the show. I'm really excited about it. If you don't know Amanda Knox, she has a pod too. Google her. She had an incredible nightmare story. But I'm really looking forward to getting Amanda on here. And she's another warrior for justice. And you'll get a Songbird update this weekend because Lauren Brightpachenko is going to be sitting right next to me at the True Crime Podcast Festival. So there you go. So yeah, we'll give you a little update. We'll give you what we can give you thus far. But there's some amazing shit going on with that case. If you haven't listened to Songbird Road, right after you listen to the Gacy tapes, go and listen to that. So you can wait on Garcia because I'm still not done and I don't need you bitching at me, even though there's been 66 episodes, which is 6 times the length of a normal podcast. So I've given you a huge amount of content there, but I get how people want the story to wrap. So I get it. Yeah. So, all right. So those are a couple things that we can look forward to that I've got on the plate. So, hey, we'll see you Friday. I love you guys. Thank you. Wait, I saw a couple more, Songbird Road update. Thank you again, Tracy. So yeah, I'll get Lauren to spill some tea on Friday when she's chatting with us. So, I love you guys because without you guys, I'm just an old man talking about a whole bunch of cases.